Consider a junior doctor administering a drug at 10 times the required strength, or a police officer failing to redirect traffic away from a known danger. When we see these events, we often look for subjective fault or moral blame. The law, however, views these scenarios as a rigid structural equation. This equation is built on two foundational pillars: establishing a duty of care, which is a question of law, and proving a breach, which is a question of fact. To solve these problems in an exam, you must use the IRAC method: issue, rule, application, and conclusion. It is the only way to convert chaotic facts into a coherent legal result. Strictly separating the legal existence of a duty from the factual breach of that duty is the most effective way to secure marks in a tort law exam. We begin with the primary filter, determining if a duty of care exists. For established duties, simply state the precedent and move on. A common error is applying the Caparo Test, foreseeability, proximity, and fairness to every single scenario. The Supreme Court clarified this in Robinson. The Caparo Test is exclusively for novel situations where no precedent exists. Using it for an established duty is a technical mistake. The strictness of the duty filter is most obvious in cases of omissions, the failure to act. Under Stoven v. Wise, the general rule is that there is no legal liability for failing to prevent harm. You are not legally required to be a good Samaritan. However, exceptions exist. In Home Office v. Dorset Yacht, officers left young offenders unsupervised near a harbor. The youths escaped and damaged a nearby yacht. Applying our IRAC method, while this was an omission, the officers had a special relationship of control over the offenders. That control created a positive duty to prevent them from causing foreseeable harm. These rules act as a policy brake, preventing a floodgate of litigation that would otherwise overwhelm public bodies and private citizens. Once established, we ask if the duty was breached. This is a question of fact based on the reasonable person test. This test is fiercely objective. The law judges the task, not the person, stripping away the actor's internal state or lack of experience. We see this in the classic case of the underskilled defendant, Nettleship v. Weston. A learner driver panicked and crashed, injuring her instructor. The court held her to the exact same standard as a fully qualified, reasonably competent driver. This is a policy decision. Because driving requires insurance, the law socializes the risk. A pedestrian's right to safety does not decrease just because the driver is a beginner. Conversely, we have the skilled defendant standard for professionals. Under the Bolam test, a professional is not negligent if they act in accordance with a responsible body of professional opinion, but Bolitho adds a caveat: professional consensus is not a total shield. If that body of opinion lacks a logical basis, the court can still find a breach. The law's refusal to make allowances for inexperience is what guarantees a universal baseline of safety for the public. Reasonable care does not require the absolute prevention of all harm. Instead, it requires weighing the risk against the reality of preventing it. First, the court considers the likelihood of harm. In Bolton v. Stone, a woman was hit by a cricket ball that had been hit out of the grounds. This had only happened 6 times in 30 years. The court ruled that ignoring such an exceedingly rare probability did not constitute a breach. The second factor is the seriousness of the potential harm, as seen in Paris v. Stepney. In Paris, the employer knew the mechanic was already blind in one eye. While the likelihood of a metal splinter injury was small, the outcome for this specific man was total blindness. This increased gravity of harm meant that reasonable care required providing goggles, even if they weren't standard for other workers. Finally, courts must consider the cost and practicability of precautions and the social utility of the defendant's actions, like a fire engine taking calculated risks to save a life. A breach only occurs if the defendant failed to take precautions that were proportionate to this specific calculus of risk. Procedurally, the burden of proof rests on the claimant to show a breach on the balance of probabilities. There are specific tools to help when direct evidence is difficult to obtain. Section 11 of the Civil Evidence Act allows a relevant criminal conviction to serve as presumed evidence of a civil breach. A driver convicted of careless driving is presumed negligent in a later civil suit. If direct evidence is totally absent, we use res ipsa loquitur. The thing speaks for itself. In Scott v. London and St. Catherine Docks, a sugar bag fell from a hoist. To use this maxim, the defendant must have exclusive control, and the accident must be of a type that typically does not happen without negligence. If these criteria are met, the court infers negligence. This forces the defendant to provide an alternative explanation to avoid liability. Be careful, these are exceptions. Relying on res ipsa loquitur when a direct factual analysis is possible will result in lost marks. A negligence claim is an exercise in structural discipline. First, filter facts through the duty of care. State the precedent or apply the Caparo Test. Second, apply the standard of care. Strip away personal traits and weigh precautions against likelihood and gravity of harm. Even after proving a breach, the analysis isn't over. A claimant must still navigate the hurdles of causation and defenses. Mastering this derivation is the only way to transform real-world accidents into authoritative legal conclusions.